Welcome. Welcome to A Taste of Justice. I'm Professor Angela May Kupenda. Solely for informational purposes, I'm a professor at Mississippi College School of Law, but all views expressed here are my own. This series is about a lot of things. It's about the courses I'm teaching this semester and giving my students some supplemental information as we study remotely, but it is also about all of us. The Constitution says we, the people, in order to establish justice. And I believe the way to more justice is by learning about the Constitution, which leads to enlightenment, which will lead us to justice, or at least a taste of it. My students have been doing some fascinating work. We've covered the basic principles in constitutional law. Now then they wrote position statements on current constitutional conflicts. Their position statements had to pick an issue of pressing constitutional concern, and there are a lot of them right now. Then they had to evaluate it. They had to argue the opposite side from their own position and then argue their position. In addition to doing a written document, a written position statement, they also have been doing presentations, 10-minute presentations in class, followed up with questioning by their classmates and some questions by me, including written questions I've submitted to each one of them. Now, we're down to the final 7 presentations in class, and I'm recording this actually in advance of their actual presentation for several reasons. One reason is because all of these presentations touch on issues, in my view, as related to the First Amendment. The First Amendment is a course I will be teaching in the spring, beginning in January, and I'll be posting, so make sure you subscribe and sign up for notifications so you can follow that interesting and helpful information. But all of these presentations seem to touch on First Amendment issues, and many of the students in the class have not had that course yet. So I'm studying the students, you're joining me as I study their position statements and consider them in advance. And then the students will be presenting in class next week. And hopefully this clip would have helped students to understand more the issues that they are talking about. Now, so let's get started. The first student's position statement is this: abortion is a fundamental right that should not be abridged, even if it is in conflict with the justice's religious background. So I've had a number of students to write about abortion rights, privacy rights. Those topics are covered in constitutional law. But here in his position statement, he adds an extra twist to it. He says that even if a justice is opposed to abortion, opposed to it, based on the justice's religious views, the justice still should adhere to the law and protect that constitutional right, even if it is in conflict with the justice's religious perspectives. He argues in his position statement that the justice should put his or her religious views to the side and decide a case based on case precedent and constitutional principles. Now, I've already sent him a number of questions even before he presented. And one question is, are we expecting too much if we expect justices to put a portion of who they are or how they see themselves to the side as they decide a case. Now, a long time ago, well, not real long, but a while ago, Justice Clarence Thomas made this comment or something to this effect. He says that when he is deciding a case, he strips down like a runner. He lays to the side all of who he is, and then he decides the case. Now, some people may say he may do that sometime, but does he do it all the time? And then others may wonder, is that the correct approach? Consider, if one justice is laying to the side who that justice is, and that justice brings something unique to the court, but other justices are not, then you're leaving out a very valuable perspective in reaching a result. So I sent him a number of questions. Another question was, what happens if a justice does not follow precedent, if a justice follows their religious views instead? Is that an establishment clause problem? The separation of church and state. And if it is an establishment clause problem, who is there to enforce it? Usually the court draws those lines, but if we're saying the court is violating the establishment clause, where does that leave us? He has a fascinating statement. I've been sitting here studying it. Great job. Now, the second statement that's going to be presented is this: why a constitutional packing of the US Supreme Court would only exasperate the politicization of the judiciary. He says that if Congress expands the size of the court for a court packing, so to speak, then that's going to make the court even more political than it is. Now, he believes that court packing is indeed constitutional, but he argues that the court packing scheme is a result. He says it's a scheme and it's a result of Congress having abrogated their responsibilities. And if Congress would do their job, then he argues the court would not be as political. Now, I have some questions for him too, and he is distinguishing between political decisions of the court and decisions of the court about the Constitution. But my question for him is it that simple to make a distinction? I mean, consider, was Plessy versus Ferguson separate and unequal, or separate and equal, as the court said? Was that a political decision to maintain the power of whites or the inferiority of Blacks? Was it a political decision? Or was it about the interpretation of the Constitution? What about Bradwell versus Illinois, saying that that a state could prohibit women from becoming attorneys? Was that a political decision, or was that a decision about constitutional interpretation? Cooper versus Aaron, Brown versus Board of Education, we can go on and on. So one of the questions I sent him was, how does he distinguish between the court taking on a political role that he disagrees with and the court interpreting the Constitution? And is it simple to tell the difference? But again, just a fascinating read. I cannot wait to hear his presentation. Now, we have two that we're going to hear from on next week, and they both have similar topics, but they take different positions. It's going to be so much fun. Okay, here's one. Freedom of religion and assembly under stay-at-home orders for states to prove that their stay-at-home orders restricting religious gatherings are constitutional. They must satisfy the strict scrutiny standard, proving that there is a compelling governmental interest in mitigating the spread of COVID. If states lay out alternatives for these gatherings, then the stay-at-home orders are likely constitutional. Now, here she argues that the stay-at-home orders that also affected churches, she is arguing they are constitutional, but only if they meet the highest, most exacting level of review. And she also added in her argument that the government would have to sort of lay out or explain what the alternatives would be for churches in order for those to be deemed constitutional. Now, I'm going to come back to the questions I have for her, but her statement is just riveting. It is so interesting to read. Let me give you another one. His is different. He says, it is well within the government's right to limit our constitutional freedoms if they are doing in service of a greater goal. So too can the government limit religious freedom together to stop the spread of disease during a public health crisis. So basically, they're taking two different views of the same issue. One is saying religious rights, freedom of exercise must be paramount. We're going to require the government to satisfy the highest level of review. The other student, he is arguing during the pandemic, no freedoms are absolute anyway, but during a pandemic, government can impose regulations, even on churches, without violating their First Amendment free exercise rights. Now, again, both of these statements relate to the First Amendment course that I teach next semester. I don't think these students have taken First Amendment, but they were so interested in this topic. So generally, let me add some comments and I'll tell you about my questions. So generally, free exercise, the right to freely exercise your religion, is protected from governmental intrusion unless government meets the highest level of review. What you're talking about, government. However, the court has held that sometimes governmental regulations, even if they touch your right of free exercise of religion, they may be evaluated on a lower level of review, more deference to the government if it's a general law that is just general for not just targeting religious institutions. If there is some other purpose, then government can meet just a low level of review. So really, we're going to have a great discussion looking at how they both look at the same issue and come to two opposite positions. One says low level, give government more leeway. The other say that government must meet a very high test. And I had a lot of different questions for both of them too about the free exercise clause. And, part of it has to do with, are constitutional rights absolute? Sometimes in debates, we believe or we want to say that constitutional rights are absolute. But even if rights are subjected to strict scrutiny, government can meet it. The court has said strict in theory is not fatal in fact. Now, one thing that's really different about the two is that she argues that government must propose, if my understanding of her statement is correct, other alternatives for churches before they can restrict them. He argues, as long as there's some possibilities, it's not the government's responsibility to tell you what you can do. The government just tell you what you can't do. Regardless, we're going to have a great time when they present. Both of these are so very interesting. They did a great job. Now, I think I'm down to number 4, I believe. Or maybe I'm down to number 5. Okay, lost count. Okay, so the next position statement is corporations use the 14th Amendment to gain personhood and its effects on elections called for change. Again, this touches on a First Amendment issue, and most of my students have not had First Amendment yet, so I'm recording this in advance so they will be better ready to question these students on their position statements. Do you remember a case called Citizens United? There's been a lot of debate about it. Well, ordinarily, when we think of constitutional rights, we think of rights that belong to the individual. Ordinarily, when we think of speech rights, we think of rights that belong to the individual. Occasionally, we have cases where there is an organization that brings suit, but that organization is bringing suit based on injuries to its members. So Citizens United, in Citizens United, the court held that a for-profit or a not-for-profit corporation had a speech right, had a right to engage in political speech. And if government infringes on that right, then government must meet the most exacting level of review, strict scrutiny. Now, a lot of professors and scholars wrote about that opinion after it came out. Many disagreed with it and said, how can you give a corporation the right of speech? Will you give a corporation a right of privacy next? A corporation is not an individual. But the court held that a corporation could and did have this right, and government could not infringe unless government met strict scrutiny. Now, this is about campaign funding. The area can get to be quite complicated. But in his statement, he argues that he is not so much, I guess, opposed to Citizens United, if I read him correctly. He is concerned with the expansion of it. How far will this go? How far will it go? And whether that is stepping away from the intent of the First Amendment and the Constitution to protect individuals. Will corporations then have rights of privacy and expanded speech protections? So he believes the expansion needs to be curtailed. Now, you say this is getting more complicated, isn't it? It's going into some specific areas of the Constitution beyond what we've already talked about in the earlier clips. Okay, and I got another one for you, right? This student says qualified immunity diminishes our constitutional rights. Now, you're like, what? Okay, what is qualified immunity? Now, while I've been recording about my common law class, I have also been recording on my civil rights lawsuits class. In my civil rights lawsuits, I posted maybe about 7 clips about it. It covers this concept of qualified immunity. Now, ordinarily, we think that when our constitutional rights are violated, we will get a recovery from government. That's the way we ordinarily think of it. However, to vindicate your constitutional rights, generally, you're going to file a suit called Section 1983. In Section 1983, it says that, well, not the statute, the court's interpretation of it says that even if your rights have been violated, an officer may be entitled to some kind of immunity. Now, she is concerned in her position statement with qualified immunity. Qualified immunity is the immunity available to executive officials like police officers, for example, or public school teachers. What happens then under qualified immunity, even if your rights are violated, there is no recovery if the officer did not violate clearly established constitutional rights of which a reasonable officer would have known. There's been a lot of criticism about the expansion of this doctrine of qualified immunity. And the result is that a lot of individuals are injured by government, but have no recourse in terms of a financial recovery. So her argument is that we have constitutional rights, but the concept of qualified immunity diminishes them. And so she disagrees with this principle of qualified immunity. And again, you can read about those also in some of my other clips about civil rights lawsuits. I have two. One says qualified immunity now and then, part 1, and qualified immunity now and then, part 2. And like all of the others, her position statement is fascinating, and she's already responded to my questions. So I'm sure my students are going to learn a lot from her presentation too. Now the last one, and you're going to see, well, you're going to see why I put it last when I get to the end of his position. Transgender military policy. Is the Trump administration ruthless or rational? Serious policies demand serious evidence and a respite from politics. At risk of landing myself in the mushy middle, I refuse to take a stand based on bipartisan ideology. Now, wait a minute. Part of the position statement is you must take a position. So I imagine here he's trying to assert a right not to speak, a right not to take a position, even though that was part of the assignment. But we'll address that later. But right now, we're going to look at the policy he's referring to, the transgender military policy, and how transgendered individuals are treated in the military. I had some questions for him. One question was, when you look at various groups that were excluded or segregated in the military, for some of them, their full participation in the military led to more vindication of their rights at home. I'll give you an example. Black people were segregated in the military, excluded from certain positions in the military. Then when many of them, including my uncles, served in the military, then they returned home to a segregated situation. And they said, how can I serve in the military and then return to a segregated society? We need to make change here. And then the same in terms of women. And we know in terms of as to sexual orientation, that once there was a don't ask, don't tell policy in the military that has since been eliminated. And so now we have, and I want to add that after that, of course, we now have same-sex marriage being constitutionally recognized. And so now we have this issue of the current administration's policy regarding transgender military personnel. And his statement examines this, but then he says that he's not going to take a position on a political issue that's divided into two sides. You know, I had some questions for him. Again, going back to an earlier position statement, I said, what is political and what is about the Constitution? You know, some people say we're having political differences. Are we having just political differences, or are the differences deeper? Are the differences about who is included, who gets included, and we the people? And what does justice mean? Does it mean justice for all or justice for some of us? Regardless, I just want to say this student, his position statement is also amazing, very interesting to read, and I'm sure it's going to be a great presentation. All 7 that I have referred to this evening, they're taking the class on to another level to look at how constitutional law relates to the First Amendment, and also how constitutional law relates to the Civil Rights Lawsuits course and First Amendment speech and First Amendment religion. So it'll be a few months now before you see me again. Go back and watch some of the older clips, right? If you miss me too much. But in January, I hope to be teaching First Amendment. And oh, it is a fascinating course. One little amendment has generated so much law, so much litigation, so many principles to debate. So I look forward to posting on that. In the meanwhile, subscribe, sign up for notifications so you'll know when I'm back. And thank you. Thank you for walking with me on this path as we walk toward justice. We the people, in order to establish justice. This series is for all of us. Hopefully, learning about the Constitution will bring us more enlightenment, and hopefully more enlightenment will take us marching right on into justice. And if we don't walk right into justice immediately, maybe we can have at least a taste of justice. Thank you, and I'll see you in a few months.